Got a question asking, if you were not served an eviction properly in your hand, can it be thrown out of court? Hi, my name is Rob Wells. I'm the Landlord War on TikTok and YouTube. Please feel free to like, share, and subscribe to our videos here. Now, to answer this question, there are two things to consider, okay? Because first off, for your grounds for eviction, or what we call cause of action in legalese, basically, usually a California landlord has to serve some type of termination notice. It could be whether it be a 3-day notice to pay rent or quit, 3-day notice to perform if the tenant's not doing, what they're supposed to do on a lease, or like a 30, 60, 90, or 90-day notice of termination of tenancy. In all of those types of terminations of tenancies, when you go to the eviction court or when you file an unlawful detainer, one of the essential elements you will have to prove to a judge or a jury is that you properly served the notice, okay? That is one element that a landlord is responsible for proving in court, okay? And it doesn't necessarily have to be served personally, okay? That it personally in your hand. It's a misconception in a lot of places that, a tenant has to be personally served. No, per California Code of Civil Procedure 1162 Subdivision A for residential tenancies, you can serve in 3 different methods under that code section, okay? Obviously, personal service is the best one under the law, but you can also serve by substitute service, which is giving it to another adult that's at the property and then properly mailing it to the resident address, or if no one appears, you can post and mail the copy of the notice, okay? Now, if you're talking about serving the unlawful detainer complaint, those rules kind of are similar, different code sections that govern that, but it's a little bit different if you're challenging service of the unlawful detainer complaint. Okay, there's special motions. Probably the motion that you'd file would be like a motion to quash, and that's basically a type of motion you'd say it basically says in English, hey, court, I wasn't properly served the eviction complaint. I need you to order that the landlord serve it properly. Okay, that's what it basically a motion to quash is. Okay, so if we're talking about serving the complaint itself, that's a different procedure, but it kind of follows the same rules. Okay, I'm not going to get into nitty gritty here because there's so many technical rules here. Okay, but my point is this. Okay. For landlords and tenants that watching out there as well too, particularly for notices, if you do not serve the notice in a legal fashion as prescribed under code section 1162 of the Code of Civil Procedure for 3-day notices, and then you have to serve your 30, 60, or 90-day notice if you're terminating a tenancy. If you're a landlord that can terminate a month or periodic tenancy without cause, basically, those types of notices are governed under Civil Code Section 1946 and 1946.1 for residential tenancies. They're kind of added together. And then if you're serving, terminating the tenancy at will, basically, and what that is, it's basically a tenancy that doesn't charge rent, that type of thing. Look at our videos for more details. You have to use Civil Code Section 789. Civil Code Section 789 governs terminating tenancies at will. Follows similar. It incorporates Code of Civil Procedure 1162. And on all these terminations of tenancies, they generally incorporate Code Section Code of Civil Procedure 1162. Okay, but with termination of tenancy under Civil Code Section 1946 and 1946.1, you could certify mail your termination notice. That's our registry mail it as well too. So that's the one plus. Here's my thing, folks. Okay, listening to all this, if you got confused by what I told you, the problem is the rules are very confusing. Okay, and if you don't follow the rules to the T, your case could be thrown out of court, basically, because one of those elements, like I said, is you have to properly show to a judge or a jury that you properly served the tenant, okay? So that's where a case could be thrown out if you don't do it right, okay? Most common thing that I see people trying to do is serving termination notices by email. Okay. If it isn't like what we just said under section 1162 of the Code of Civil Procedure, it's going to get thrown out generally. Okay. So like email is just not a prescribed method. Okay. If you admitted that in court, hey, that's how I served my tenant, etc., your case is getting thrown out. Okay. So it's very important that you know the rules. And it's very important that you have the evidence to show that you properly serve someone so you don't get your case thrown out. Okay. Here's the thing. California landlords, if you're in the Northern California area and you need help with terminating a tenancy, all these rules confuse you, that type of deal, feel free to reach out. We might be able to help out. You can go to our profile down below, go to our website and book a free case review session. Okay. And we'll see if we're a good fit or not. Put your comments, questions down below. Until next time, folks, I'll talk to you then. Thanks.